how are you going to resolve my case? When is it going to get dismissed? The number one question a defense attorney gets. This is Attorneys with Swag, know the rules. And today we're going to discuss all the ways you can resolve a criminal case, from the very lucky decline to prosecute to the very scary getting an acquittal after trial, or even worse, a guilty verdict. As I said, this is Attorneys with Swag. I'm Eugene Toussaint. And before we start, this is live. You can ask your questions. We will be answering questions after we start. So as you probably guys know these guys already, but please introduce yourself to the audience.
David Hourly.
Mehdi Ismidi. Nice to see you guys again.
What's up?
And what we're gonna do is we're gonna start from the very beginning. Not a lot of boroughs do this, especially not in Queens where I practice. But the first way that a criminal case can resolve is something called decline to prosecute. DP. And luckily we have an ex-prosecutor here, so explain like how exactly that works. It turns out there's not a statute that is connected to; it's just connected to the general authority or a prosecutor. So explain that to the audience.
So there is a statute. The statute that defines the authority of a district attorney or a local prosecutor actually grants, under the Constitution of the state, the power to apply prosecutorial discretion to the DA's office or the prosecutor's office. So that's actually where the power comes from. It's not in a penal law or a CPL or anything like that.
Is it the same? Authority or power that grants law enforcement, like police officers, from the discretion to arrest or not, or charge, for a crime? Because police officers have discretion to, even if a crime is committed in front of them, too.
Yeah, it's basically an executive privilege. It's an executive power. So it's sort of like we're going to decide certain ways to apply and which things are appropriate for, essentially your prosecutor's office are part of your executive branch. So the decline to prosecute essentially happens under multiple situations. Number one way is if there's no crime. Police have made an arrest, they're able to assess almost immediately that there's no crime, and it's determined by supervisors and the district attorney who's investigated the case that the case cannot be drafted up. There's no way to allege that there's a crime. There's no way to make even a close to factual argument for a case. That happened a lot for me as a young prosecutor, because we get these cases where the officers had not spoken to their victims, right? And so we would not write those up. Like we needed to know what the crime was, what the injuries are, what the circumstances are, so we know what to write up. Is it a felony? Is it a misdemeanor? Is it a violation? These questions had to be answered. And there's a lot of times where the officers didn't have that answer. It's funny, since 2020, when the discovery laws went into effect, I'm noticing now there's a lot less of this. There's a lot less of this decline to prosecute when there's no investigation. Why? Because they're writing it up based solely on whatever's in the police report, the 61 that they get from the police NYPD complaint.
You get it. So I've turned in a friend or two in the Bronx, and in multiple boroughs, but mostly in the Bronx. And in the Bronx, they do DP a lot. And they'll DP even if they say it's a domestic violence case, and they speak to the complainant, and complainant very adamantly does not want to pursue the charges, regardless of how the 911 call occurred or the original interaction with police occurred. They'll talk to the prosecutor and be like, I don't want to pursue these charges, and then they'll DP it. I've never, obviously it might be happening in Queens, but I've never turned someone in Queens and had that happen.
Well, I actually have been DP. The second time I sued the city and NYPD was based off of a false arrest. In 2018, while I was working at Legal Aid in Manhattan, I was arrested in Brooklyn, held for about 7-8 hours, and I could tell the whole story, but long short of it was arrested, brought to the precinct, held there, processed, held there for about 7-8 hours. Was arrested at like 5, got released at like 1, got home at like 3:30.
Now,
and then sued and got some money out of it. And it was the second time I sued NYPD.
That's the good part.
Might be one of the few people that's got to sue the New York City Police Department in the city twice. And
now,
this time he settled.
Obviously, it's not something you would necessarily know, but I guess to a certain extent, like a prosecution, the prosecution office is kind of putting the NYPD, exposing the NYPD to a wrongful arrest by DP, by definition. Not necessarily.
Yeah, not necessarily, right? Because when the police are acting based upon information given by an identified civilian complainant, they can't really be sued for that. That's not malicious prosecution. That's not unlawful arrest. They're acting on. They have probable cause based upon what's referenced to them. And because of the agreement with the NYPD, the city of New York, outside of New York, it's a little different because there's different rules. But in the city of New York, they have these things called I-cards. And what is that? It's literally just
it's a way to get around
investigator essentially saying we have probable cause, and by having a report that's concluded to be probable cause, local law enforcement, any NYPD officer who has that access to that report can make an arrest based upon it. It acts like a warrant, even though it's not subject to judicial intervention and review.
It's a warrant without a warrant. It's a warrantless warrant.
Now, when deciding
it's constitutional though.
when deciding to DP, are you like applying the facts to like the element of the specific charges? Like, is it that in depth of analysis?
I think it effectively means that the prosecutor who once, because you know how like when you read you're at arraignments and you read the packet and it says arrest charge, you read the arrest charge and then you read the actual charge at the arraignments, and it's different a lot of times. That's because cops are dumb and prosecutors are slightly smarter. No, they're lawyers, so they know the law at a higher level. They went to higher training in school, so they're the ones that actually get to write up the complaint. That's a prosecutorial instrument that's used to prosecute a person, and then so on and so forth. It's not the cops.
Just to be fair,
I'm not fair.
Patrol officers are responding to calls. They're taking reports. Maybe somebody's there, maybe they're not there to be arrested, so they can't bring the person in. The case gets sent to a detective. The detective does a review, assesses it, interviews the complainant. The complainant's still cooperative. It's been 2 days since the case. Comes time for the case to be done, and the report is criminal mischief, which requires permission and authority language. The report is, grand larceny, criminal mischief for a felony, which is $250 or more of damage in value. What happens is now you're in the complaint room. You're the prosecutor. You're speaking to the officer, and the officer's like, I arrested this person, but I've never spoken to the complainant. I don't have an affidavit. I don't know what the value of the damages are. You can't make out the charge that was assessed when the original case detective reviewed it or the original patrol officer got the report. So you have to get a hold of that person. So a lot of times what we do is it's not called decline to prosecute, it's called defer to prosecute. Mm-hmm. So what that means is the person's been arrested, the statute of limitations starts running, speedy trial is not run because it's not brought into court, but you know that this person's been investigated, arrested, notified there's a case, we know something's going on. If the police end up getting this person and bringing them in, bringing the information that's necessary to charge the case can still be charged. But a lot of times what happens is because there's not that information, they will not file it. What I am shocked now is I'm seeing cases where there's double hearsay, where it's Officer 1 is informed by Officer 2 is informed by complaint.
Oh, that happens all the time.
Yikes. And honest to God,
that's a facial sufficiency.
That is facially insufficient.
Yeah.
That is
That's
objectionable behavior.
On its face.
Like it's objectionable. Like you're relying on hearsay from hearsay, and you have no way of corroborating it or establishing it, and we're just basing this on a report. If we could just write these cases based on whatever the police put in their report, we wouldn't need the officers or the complainant or anyone else. You could just have a case without due process.
Procedure law, right?
Yeah. There's nothing worse than seeing a complaint where it's like officer was told by officer that he watched the video that this guy was in it. And it's like, what? Yeah. It's like, what? All right, so that's DP. And just I guess I should have said that at the beginning. What we're going to do is try to flow through these, because there's a lot of different ways in which a case can resolve. And we're going to try to flow through them as they come up through someone who's journeying through the criminal justice system. So the next thing, because it can actually happen at arraignments, is facial sufficiency. Now, my dream is to get because it's facial sufficiency that can be on papers after you get arraigned, but there's one that can also happen at arraignments, which is CPL 14045, which is basically like no reading of these complaint and any formation of it would ever make out a crime. For example, in theory, they can't fix it. They can't fix it, exactly. So a good example is like you get charged for assault 3. If attempted assault's not on it, they get charged with assault 3, and the complaint literally describes someone taking a swing and missing.
So
You can't have assault 3 in that definition. Now you could change it to attempted assault, but you can't have assault 3 in that under that definition.
Well,
that's what the complaint says.
also, like in facial sufficiencies, depending on the time frame, like they can supersede that, right? Like
yeah,
they could write but then the superseding information is. No, I just you know
he's right. Like
superseding.
The reality is, even if you were to win that motion, right, the judge would not be able to immediately. It wouldn't be a dismissal with prejudice, without prejudice. They'd have time to amend, and they basically have as much time as the trial clock allows.
Right, the 30-30 clock.
But the case law basically.
This one doesn't.
They wouldn't get arraigned. Right. Like the case would get dismissed because the judge doesn't have. The argument is that because they didn't make out a crime, the judge doesn't have jurisdiction over the defendant.
They would have to rearrest him.
This actually happened one time when I was a prosecutor. I was in charge of arraignments. It was a nighttime, and someone screwed up. So the system that creates the complaint, it's a bunch of different data, but you also have to type in information that's kind of really old. And I think somebody forgot to populate the data into the complaint. So the factual portion didn't get put into the complaint, even though the summary explained what the basis was. So we had to catch it, and then we had to send it back upstairs to amend. But like, for example, in the situation where you swing and you miss and you don't actually make contact, you would just move to orally amend for an attempted assault. You just go, oh, judge, this is clearly a scrivener's error. We move to orally amend to make this to reduce to attempted assault. And then the judge can take notice and write 110/120.00 subsection 1, and then it can move forward on that arraignment.
Yeah, I remember I had a case where I thought I had a shot. It was it when threatening someone with a knife?
Menacing.
The client was, and I think like it was in the complaint. She was in a kitchen and she was making herself a sandwich. So she had a reason to have a knife in her hand, and she just had it. She's like, oh, like how about you just get the fuck out of my apartment? Like she said that to him, but she's like, yo, I wasn't like threatening him with it. I was just making a sandwich. So I was like, Your Honor, are we trying to say that you can't make a sandwich in your own house and tell someone not to get the fuck out? Like are we saying you can't tell someone to get the fuck out of your house with if you're making a sandwich, you gotta put the knife down and then get the fuck out of your house? Like,
so realistically, that case probably had a physical menace charge on it, which is the B misdemeanor. It wouldn't have he could have been arraigned on the B misdemeanor.
So that wasn't part of it, but yeah, they didn't.
Old ladies
let
are
it go
scarier
past.
than young ladies.
They didn't get past. All right, so that's facial sufficiency. Now that's at arraignments. That almost never happens.
Motions too.
And then motions.
Yeah. So which I think is a larger part of facial sufficiency practice,
exactly.
which is also a large chunk of how cases get dismissed.
So I will say this. It's my practice not to file the facial sufficiency motion shortly after arraignments.
I agree.
I will wait until they think they're ready.
Yeah, 100%.
And let them make the mistake.
Yeah.
And then I will sandbag them with the motion that shows that they should have known how to read it.
And the reason is you're playing the clock, right? Because the ultimate...
We're not playing the clock. We're holding them to their responsibility.
Whatever you want to say. I mean, like, there is a 30-30 clock, and that is the majority way that cases get dismissed. So not to jump ahead, but strategy is all intertwined into all.
So, but just the funny thing is, this is always typically tied to 30-30. But I guess explain the fundamentals of a facial sufficiency motion, right? It's the four corners of the document
provided at the time.
Explain to the audience because we're kind of talking fast. What exactly is a facial sufficiency motion? What is it accomplishing, and how does it go about accomplishing it?
Confirm for me, it's a CPL 17020, right? That's what we're talking about.
I don't know the CPLs by heart. I can tell you what the statute.
115.
I can tell you what the case law says.
But the motion to dismiss is under 17020, right?
Yeah, you tell me, baby.
Without looking it up, I know it's in like when you file your motion, it's going to be CPL 115, which is your facial sufficiency, which explains what's sufficient. And then 17020, which talks more about indictments, but you apply it to your complaints as well.
Okay.
Essentially, every single accusatory instrument has to have it has to put the person on notice of the basis for the charges. It has to have prima facie showing of the allegations. So it doesn't have to prove the allegations, but it has to allege the elements of the crime. So, for example, in assault, you have to show
non-hearsay.
You have to show conduct, right? You have to show an act, and you have to show, so it's mens rea, your intent. You have to show an act, and then you have to allege the result, which is physical injury. That's a simple example. A more difficult example would be reckless driving, right? You have to show that the person is actually driving, right? That they're in possession of a vehicle or a bike or a motorcycle, whatever it is, and they're driving it, operating it, and that they're actually behaving in a reckless manner. That can't simply be speed. Right? It has to be more than that.
So like another example that is like I think commonly used is like when police say arrest somebody for drugs, right? They say
Say it again?
For drugs, right?
Okay.
So they'll say a complaint will read like, we arrested the defendant, we found crack, or we found cocaine, or we found heroin, or we found marijuana, or whatever the fuck drug you want to use. I don't know why I keep listing different drugs. I feel like
You're in the loop. You're in the loop.
I feel like I had a moment where I'm like, now I'm with all different types of drugs.
PTSD flashback.
I was going to say something more inappropriate. But I'm learning. But like this, the complaint read like we recovered, crack cocaine from the right front pocket, based on training and experience, right? And then that would be facial insufficiency, right? Because one, they're using what would be, what's called conclusory language, which is a common, attack that we use for this is they're just saying crack. Well, how do you know it's crack? You got to describe the color. You got to describe the packaging. You got to say, it was subject to a field test or not. Like there needs to be like factual descriptions to lay out every element of the charge. So like, if you were in possession of a controlled substance, you need to have possession, you need to knowingly possess it. It needs to be a controlled substance. So every element has to be, it can't have conclusory language. You can't just say he had crack. You need to know how to say how you had crack.
Describe the injuries.
Exactly. So like for assault, it's like, it's just, everything has to be described. Every element has to be met.
So another thing that's interesting about facial insufficiency is every complaint under 115 and 17020 has to have a date, location, approximate time. But I found out that in sex crimes, that rule is extremely broad. Yeah. And it's construed to the point where they don't even have to they can specify months, a range of time of years, months.
Yeah.
And they could say they don't have to specify an evening or location. You don't know what day.
Yeah.
So then you are raising a defense based upon an allegation to an incident sometime between 8 months.
Yeah.
Where you have to now find which 8 o'clock in that 8 month span is the time that this one incident happened. And
or multiple, and they don't, and what multiple could mean.
Yeah, but multiple is at least easier. Like your multiple, you can argue like, oh, they're describing a course of events. Yeah. But when they're describing one incident, one evening out of 160 days of time, you're like, this is madness. So I always I remember the first time I ever saw that, because I've never written a case up like that as a prosecutor. So when I was a defense attorney and I saw it was actually in the Bronx.
Oh, really?
And I wrote a facial insufficiency motion. I argued the case. I had good case law. The judge was just like, nah, I'm going to allow it. Didn't actually give a reason, by the way. Didn't explain how this is showing a prima facie basis.
How you're able to prepare a defense based off of that.
Exactly.
Yeah, right.
And honestly, after we wrote the motion, the prosecutor was more convinced they gave the guy a violation. They were convinced by my motion more than the judge was.
Wrong shit.
Yeah, it's funny. So I was thinking about one example of trying to get it at arraignments, but the most egregious example of this, I had a case. It was unauthorized use of a vehicle, right? Mm-hmm. And what the complaint said was, and unfortunately, this guy had an extensive record. This is pre-discovery days, so you can get put in on a misdemeanor. The charge was it was unauthorized use of a vehicle. And what the charge was is that he was walking down a block trying to enter cars, but he didn't successfully enter a car. So maybe I guess you could have argued attempted unauthorized use of a vehicle, but even being in a vehicle, I forgot the language of unauthorized use, but you have to control the vehicle or damage it if you can't actually operate it. So you can't have authorized use of a vehicle just by entering a vehicle. So, and this guy hadn't even entered it. So
This was your case?
Yes. What do you mean?
I could swear, in a training, this was an example case that was.
It got overturned. It got overturned in up there, wherever it gets overturned.
In my training class, this is one of the cases that he used.
It was. I'm telling you. I argued 145 at arraignments. They didn't let me get it. So the 170 date came. They were able to convert it.
He was in.
He was in. I like pleaded with the judge to release him. That this is the
Jeez.
most bullshit charge I've ever seen in my life. The judge wouldn't release him, and because of that, he had to eat it to get out. And I was disgusted. I told him, I was like, I swear to God, I'm going to make sure, because it's a misdemeanor, right? So like, there's no automatic appeal. Yeah, he did have a record, but I was like, this is going to get overturned. Like, I literally went in the back, I got his signature to get the paperwork filled out, and I made sure that fucking appeal got signed. Because I was like, this is the craziest shit I've ever seen in my life. And like a few years later, it got overturned.
You got to put that case up on your mantle.
I should, right? I guess I should give him.
Yeah, that's a good one. I guess I should give him.
Now, so I was gonna move over to ACDs and stuff like that, but I realized it's probably more applicable at this time because it's almost like facial sufficiency is a no true bill, right? Because a facial sufficiency motion, you can only have for a misdemeanor. Now you do have a bite of the apple once the case gets indicted, but I guess the equivalent of the elements not being there would be a no true bill, right? So explain what a no true bill is to the audience.
You want me to do it?
Yeah, of course. This is the A shit. That's why I shifted to you before. I was like,
yeah.
Well, I felt like they would have a way of describing it that would be just hilarious.
You know what it is?
Jump in.
You always lay down the fundamentals so well that I can paint way more on a nice canvas than I can. And me describing it terribly. And there's so many holes.
All right, so the grand jury is a secret proceeding. What that means is there is a judge who impanels grand jury panels, which are usually 23 members of the community in each county, and there'll be multiple, sometimes 5, 6 different panels, and then special panels, right? What happens is at least a quorum, that's 19 of them, have to have listened to all evidence in a case, and at least 12 of them have to find that there's reason to believe that a felony was committed. So that means
sandwich. Sorry.
So that means they get presented with evidence. They get presented with what that means is witnesses, videos, physical evidence, lab tests, reports, affidavits. Which is another thing. Like at trial, people got to come and testify. For example, in a grand larceny, like a vehicle theft case or auto stripping case, they just get a piece of paper. Notarized piece of paper that says the value is this. They don't even have to prove the valuation with a Kelly Blue Book or an estimation or have any actual inspection.
That's crazy. I didn't even know that.
It's just whatever. It's just they just send their. This used to happen all the time in the economic crimes unit. They just send the DI to get a piece of paper. They send the DI. The DI looks it up, writes what the value is. The detective investigator for the DA's office writes the valuation based upon whatever information he's looked at. Right, doesn't matter about the car. Then he gets the guy to sign it and notarize it, and then they enter that as evidence in the court.
Yeah.
Right. Which is, I've always felt that was kind of wild because then you get the DI to testify and go, oh, we did this and we did that and we got him to sign this and he signed it under oath and we were present when it happened. Like, and I never quite liked that. Like I was like, the guy can show up and testify and explain the car, and describe it. Like, but that's I never worked in economic or auto crimes for a reason. So what happens is then the jury gets instructed on the law, right? And there's pattern instructions that everybody in the office is supposed to use. Sometimes people go a little bit wild and don't read the instructions properly, and that's really where mistakes happen because they don't follow the instructions. They give weird instructions or they change the wording of the instructions. Never do that. Once the jury has the evidence and the instructions, you leave. So at least 19 people who listen to the evidence, at least 12 of them have heard all the evidence. 12 of them can decide, is there reason to believe that a felony was committed or not? If 12 people say there is no felony, then the case has no true bill. That means there's no indictment. There was no felony. We've kicked the case. What happens in that is you can also you can indict a misdemeanor and have that go to a trial inside a Supreme Court with 12 jurors at trial. What I always find is interesting about a no true bill is it doesn't happen.
It's happened sometimes.
You have to have a very specific case.
I mean, look, part of it is the defense bar's fault because we don't put enough people into the grand jury.
But the reason why we don't do that is because we have too many clients who who literally will not listen to instructions.
Yes,
right?
that's a
So
good
you
point.
put so you walk into the grand jury. You're not allowed to ask any. The lawyer's not allowed
We
to
can't
ask
do
any
shit.
questions.
Yeah.
We
They can't
do
raise
shit.
objections.
Yeah.
They can't introduce evidence.
Yeah.
It's not a trial.
Yeah.
So you sit with your client while your client
kangaroo
gets asked
court.
questions by the prosecutor in a courtroom where they've done all the presentations, and you don't know
It's
what
on
they
the
presented.
record.
You don't know if they showed. They don't have to give you discovery.
And
So
it
they
starts
have
with
to
them
show-
presenting. You present your story,
Yeah.
which is the best. Like depending on the type of case, you prep your client. You tell them, hey, you have to tell your story, but you're gonna start off with a little bit of background about who you are. Like, you gotta humanize yourself. If, for example, like a case that can get kicked, I've kicked
It's
it
a
before,
direct examination,
is
but under
something like a
very-
girlfriend in the car and there's a gun found in the car. And if they could prove, like, I had a client who, like, she was just a young girl. She literally got out that day. She got out of work. She was able to testify. She literally got out of work. She was still in her uniform. She gets into her boyfriend's car. She don't know what the fuck isn't in there. She gets there. She does a little crying, and they kick that shit really good. Things like what I always say is that you put in a case in the grand jury that you have to know 100%. You have to trust your client that there is
You have
not
to
a
trust your
thing that can
client.
change
Yeah.
between what you're going to testify into the grand jury and what
could
all
happen
the
at trial.
evidence will ever show.
100%.
So the first thing I said was the grand jury's secret proceeding. You don't know what the prosecutor's presenting.
Yeah.
And if your client's going to testify, they're not going to tell you.
Yeah.
Right? They'll tell you that sometimes prosecutors will give you like a taste of the evidence just to be like, are you sure you want your client to testify? Like, don't waste time. Right? Especially if they're planning to give you a plea offer later. Like, they'll talk to you. Like, I mean, at least they do to me. I don't know about you guys.
I mean, it depends.
you guys have been institutional for a long time. I don't know.
It
happens.
depends on your relationship. It depends on the case, but it also like you can't. The trust level is because at least in Manhattan when I was there's a lot of bluffing and bullshitting, and there's a lot of bad offers, and it's a different type of district attorney.
A video is a video, a recording is a recording, right? Like if you get it, you get it.
Yeah.
You know.
So I had a very interesting case. I ended up getting. He ended up hiring, even though, whatever. Like, so it was an attempted murder case. And the client was adamant that he didn't do it. That he was just there. He didn't do it. And they had video evidence.
Shooting or stabbing?
It was a stabbing.
Oh.
He was accused of having a knife, but then there was other people involved. So it was like they could have charged it like I don't know what they
There's no physical
gang
evidence?
assault like kind of situation. Even though he wasn't in a gang, but like multiple people attacking someone, and he had a knife.
Yeah.
And he was adamant that he didn't do anything, and they had a video. So I got to the 180 day, and I basically argued that like based on the letter of the discovery law, and that it's supposed to be operated in good faith. I think there's like a presumption of disclosure, and even though there is no rule that says it must be given to me prior to my client testifying, just living in the spirit of the law, my client should be able to watch it before he testifies. And I
like the spirit of the argument.
I went ham in the paint. The judge didn't want to give it to me because he didn't want to create a new standard in AP6, which is like the pre-indictment felony part in Queens. But I'm going ham, and I'm like, I had every statute that like was applicable, even though none of them was like 100. I was like, you read all these statutes, and my client shouldn't have to. The whole point of the new discovery law is that you
We should know what's going on.
You shouldn't have to get Sam back. Yeah. And so the DA's there, we're arguing, and at one point the judge just like throws his fucking glasses at the bench, and it's like, if Mr. Toussaint's correct, and it turns out this evidence, like you are withholding exculpatory evidence,
and your case is
fucked. Like not only you're fucked, you will probably get fired, and like he made him get the supervisor. Eventually, they basically said like, would Mr. Toussaint accept? Because I wanted to show it to my client. Would accept as a middle ground. We would let him watch it.
Okay, yeah.
I was like,
hell yeah.
Okay, yeah. I was like, okay. So I go and watch it. It was fucking terrible. It was.
You are not
terrible. I told my guy, I was like, bro, I'm sorry. Like, this is what they call PPM case. Right? This is A. I'm gonna try to get you the best offer I can. And in doing that, we should be polite and nice to the DA.
Yeah,
and what we just did is made it hot.
Yeah.
Hot as a fucking like frying pan.
Nah, you did a good
Yo,
job.
we got back to the part, and because I was like implying that they were doing their evidence. The DA, the judge,
they were outclassed.
The DA was like, he ain't saying none of that now.
So we should explain this. Brady material is evidence that's required to be disclosed as soon as it's available. So if for example you got a case involving a murder and they find the weapon with the DNA and blood on it, and it's a knife, and it's in Joe Schmo's house, and it's in his pocket at the time, and we know it's the same weapon that killed this guy, that's some serious exculpatory evidence. They can't hold off on that while they indict your client. They have to give it to you right away. If they don't, now prosecutors have absolute immunity for things they do as prosecutors, but what they don't have is protection from sanctions for Brady violations. They can lose their license for that. So that's why judges don't have a lot of leverage on making the prosecutors do anything, because nothing can happen to them unless it's a Brady violation.
Yeah, and I think in this situation, what I guess in speaking to my client and my guesstimation was that the video was going to be inconclusive, which is like if it's extremely inconclusive, you really can't tell who did or didn't. I assume my client wasn't involved at all, but in a way where they wouldn't show it to me. If it was, in my mind, I was like, it was
why the fuck
show
would
it
they
to
just show it to you? Yeah, exactly.
Like, why are you holding it back? In my mind, I was like, maybe it's inconclusive.
Yeah,
and he can go to the grand jury, maybe get kicked.
Yeah,
it was extremely conclusive.
But then it begs the question: why not to show you and be like, hey?
So here's the thing, right? Like, I think different prosecutors have different ways of thinking about stuff, right? And it also depends on who you are, right? Like, there are certain attorneys who just know, I'm going to actually mention the guy's name. When I worked as a prosecutor, there was this really intelligent, very capable defense attorney who works for Bronx Defenders. He probably still works. His name is Karume James. I had no problem getting permission from my bosses to present something that just made it clear, like, you need to waive. You need to waive. You need to start talking about an SCI, because I knew he wasn't going to do anything wild. When you make the decision to not go into the grand jury and rush something in, you have to do it for a reason. And whenever you're doing it, you're going to your bosses and going, "Hey, boss, I think that this could be an SCI. We have a really strong case, but it doesn't have to
What's
be
the SCI?
Supreme Court information."
Oh, okay. And I guess
Superior Court information.
I guess when you say you're going to the supervisor, you're saying this could be an SCI. Like, what is the?
We don't have to indict it. We can resolve it with that.
We have this in the
a
bag.
felony.
I know if for example, if I'm dealing with someone who's reasonable, I can talk and be like, "Hey, you should waive. Let's talk. The case is not good for your client." And the other thing is, I don't play games. I never lie to anybody about anything as a prosecutor or defense attorney. So when I say something, I mean it. So I think that having had that reputation, people knew when I said that it was to their benefit.
Yeah.
I don't think everybody has that relationship with each other. So what happens is the grand jury is a secret proceeding. That is by statute. You're supposed to keep things secret. You're supposed to keep it presented with witnesses that testify, who's in the grand jury. All that is supposed to be secret. So that's why when a defendant testifies, they have to waive their immunity, because people who testify in the grand jury get immunity from their testimony. But when the defendant testifies, he has to waive their immunity, and he has to basically put himself on the spot and make himself vulnerable to the prosecution, because the grand jury is the prosecutor's courtroom. They don't have to be a judge or anything. They're the judge now.
And we haven't said it. You said it, but it got
lost in the sauce.
The prevailing idiom about the grand jury is that you can indict a ham sandwich, meaning that the prosecutors have so much control of the process that they can indict anything. And I think what we haven't mentioned is that the standard is probable cause.
No, it's not.
It's not?
Probable cause would be great. Probable cause is what the police need to arrest you. Probable cause is what a judge needs to issue a warrant. The standard is reasonable cause.
Okay.
Reasonable cause and probable cause are not the same thing. Reasonable cause is literally lower. They can arrest you on the street. They require more evidence than they do to indict you on a felony.
Really?
Yeah. Yep.
What the fuck?
And if somebody's telling you it's probable cause, they're reading the statute wrong. It's reasonable cause.
And
by the way, that's the instruction they give the grand jurors. Reasonable cause. They don't say probable cause.
Yeah, I'm saying.
I guess I couldn't do it. Could you describe the difference between reasonable cause and probable cause?
So probable cause represents the probability of a
something
crime.
happening.
Probability is like, if
It's
we're talking
more than
statistics,
likely to happen.
like literally, if you were in a statistics class, probability is more than 60%. Right?
More than likely.
Reasonable cause means
It's possible.
you have reason
to believe it could.
to say that this could be a felony, that it might meet the standard. It doesn't mean that you believe it's probable, which means it's actually very likely, right? Probable tends to be very likely. Reasonable means, okay, I can see how this could be.
Damn.
That is a low ass standard for you to be facing a felony.
No wonder you can get a ham sandwich.
or robbery with one.
Motherfucking ham sandwich.
All right, and then I guess what ends up happening is if they determine that there was not reasonable cause, that this person did this, that, or the other, you get a no true bail.
But if there was no reasonable cause, they wouldn't even be in the grand jury. So that's the thing. It's so easy to get to reasonable. Right?
It happens. I mean, like
it's
I said,
so easy.
Yeah,
but
it happens.
It only happens,
especially when
it only happens when the person testifies.
Yeah.
They give a reason why.
They haven't. What happens is you have to have a narrative that is like
ironclad.
Like your narrative is like there's no definitive proof I'm guilty. Like it's the gun in the car case. And look, the funny thing, the weird thing about the gun in the car case is that like with the automobile presumption, right? That's rebuttable, meaning that anyone in the car.
That's also really important. The prosecution does not have any responsibility whatsoever to advise the grand jury of any defenses. So self-defense, no, they don't instruct them on that. So they tell you this is a homicide. They tell you the rules for homicide. They tell you the ways to construct it, but they don't tell you that there's also a responsibility for them as the prosecutors, if they go to trial, to disprove self-defense.
Yeah.
Which means the grand jurors don't know, as they're sitting there and they're deliberating, that they have the ability to look at this and go, well,
it's a kangaroo court.
So if you don't put your client in the court at the mercy of the prosecution, nobody's going to tell them that this is self-defense, and nobody's going to remind them that this is self-defense.
And you have to understand, this happens at the very beginning of a lot of cases, especially serious cases like homicides, where like it's critical to, you know, to what's going to happen in the future, because it's not going to be resolved with a PPI or PPM or whatever. Or
somebody dies, they want to indict it.
It's going to be a trial.
They're not talking. Right. They're not having a conversation.
And you just don't. And most people are not trained lawyers, are not trained in the art of testifying in criminal court, because even though it's about telling the truth, there is an art form to it. It's not just open conversation. It's a very technical and unique way of dialogue. And on top of that, you know, it's a risky thing to do. People make mistakes and errors, and with the stakes that high, it's a real do we do this now, or do we wait till we can do it with knowing everything, with being able to know what level of speech and understanding and so on and so forth. I mean, it's risky. It's risky.
So remember, it's not. There's no judge. You don't get the defense attorneys don't get to cross-examine.
They don't get to do anything.
They don't get to present evidence. They can't ask for instructions. They can't do any of the stuff that gives you due process. But what happens is the client, who waives their right to silence, agrees to have the information that they provide to be used against them, to be recorded as they speak. And the worst part of it all is it's a legal decision whether or not the client testifies. So if you're the attorney,
it's arson,
and you're making that decision, and your client told you, hey, I'm telling you the truth, right? Like, I'm telling you the truth, this is everything, and you believe them, and then you go in there, and then the prosecutor pulls out a video, well, now he's perjured himself. He's going to get charged with additional crimes, and more than that, you've suborned perjury, and you might need to remove yourself from the case. So now your client's even worse off.
Yeah. I mean,
this is the other misconception and this is something that I've dealt with clients with a lot, especially as a public defender, more so as a public defender, because there's a different level of interaction and relationship. It is not the client's decision whether to go into the grand jury. It is a strategic decision that is solely up to the attorney. As far as testifying in trial, that is solely up to the client, but for grand jury purposes, it is not up to you as the defendant. It is up to me as the attorney.
And look, the reality is, if you came to this live stream hoping to get a quick summation of all the ways you can resolve a criminal case, we're gonna try to roll through these a little quicker. Unfortunately, some of these topics are like they're worlds within themselves.
Yeah.
And grand jury is definitely one of them. I just hearing the depth in which we can go. We definitely probably should just do a whole episode on the grand jury. But just to like keep us moving through the topics, so before taking a plea, I realize like I'm looking at this list. Before taking a plea, something that can happen even before you take a plea, such as like ACD or plea to a lesser charge, is dismissed in the interest of justice.
Yes.
So that's a thing.
So the criminal procedural law actually has a section for dismissal in the interest of justice. And this is what's the motion? Perkins? Is it Perkins here? Motion?
People read Clayton as the motion.
Clayton motion. So there's a motion you can file for a Supreme Court case or a misdemeanor case called a Clayton motion, which allows you to ask the court to dismiss a case in the interest of justice. I've never seen a judge do this. I've never.
If somebody's dying,
Your client always has to be about to die.
Yeah, that's the only time I've seen it happen.
That's the only time. But I'm talking about like this case is you know, like for example, you have a case where I had a very good case for a Clayton motion, and in my experience, I almost never put that in the hands of the judge, because I find that if I have it, I'm going to the DA and I'm going to his boss, and I'm going to get them to do it because they're going to see it my way. Whereas I know the judges are too scared of the consequences.
I'm always very.
I think that's a very more of a strategic thing. But if you have to,
one second before we continue, cut the mic for 2 seconds. We'll be right back, guys. All right, we're back. We're just trying to figure. There's so many to do. We might make this a multi-parter, but because I know we have an audience that has questions, and we want to get to your questions as soon as possible. But
why don't we just get some questions and go back to it?
Yeah, do a little intermission for questions, and then we go back to the next step. Essentially.
So it seems like we might have a question about pleas. Now, I would say let's get past dismissal and interest of justice. Let's go to pleas, and if our lovely technician can tell us the question during that period, if that makes sense.
All right. So
makes sense, Ant?
So then, to clarify, dismissal in the interest of justice is a Clayton motion where you can get the court to do it. As they said, pretty much only happens to somebody sick. I've never seen it happen. Yeah. And so the other kind is where you go to the prosecution, you get them to see that the case is not established, and they dismiss it into justice. I had a case not too long ago where the police arrested a guy for his landlord went in the dark of night after 11 o'clock at night, woke him up, him and his son, and started beating him with a frying pan. And his roommates recorded the whole thing, but they were all immigrants. They were all terrified of these landlords.
Who with a fire man?
The landlord snuck into the crib.
And so then the police arrive on scene and arrest the bruised and beaten client and ignore everything he has to say about the guys that just beat him with a frying pan, and they had video.
So the funny is, I've been doing this job for over a decade, and it's like what police do or do not listen to. It shit don't make no sense.
They really don't.
And like I can't.
Wow.
It's not that it doesn't make any sense. It's like 80% of the time it makes sense,
And DV
but the
cases,
other 20%, it's like there's no rhyme or reason to it. Like there's no rhyme or reason. What they listen to you, they don't listen to you. Like I can never understand it. Like it doesn't make any sense.
bias.
So
It's got it.
So this is
Personal
actually a Kings
bias.
County case, and so the guy comes to me, shows me the video. I'm incensed. I'm completely insulted. I try to reach out to the district attorney's office before the arraignment. They don't want to listen. I get to the arraignment. I try to show the video to the prosecutor in the courtroom. The prosecutor starts yelling at me, going, "I can't see. I don't see anything." I go, "What are you talking about? I'm showing you a video that this entire case is a lie. You're about to arraign a client and ask for bail.
I've
and
done that.
There's no
in
basis."
Manhattan.
And she didn't want to hear it.
Yeah,
So I told the judge, I go, "Judge, I'd be happy to show you the video that this is a lie." So case gets through the arraignment, gets adjourned for 1 week. I get this prosecutor, thank God for this young man. He actually listened. He actually reviewed the video. He when came back a week later, they dismissed in the interest of justice. Now,
Did they charge the fucking landlords for doing that shit?
and here's the crutch, the real like kicker, man. The man was scared of the police. He's scared now. They don't listen. They don't
Oh,
listen to
yeah,
him. So
fucking
him
police.
and his older brother and I went to the precinct together. We spent 5 hours in the precinct trying to get them to take a report, and we showed them the video. We showed them the dismissal. We explained everything. The sergeant on duty told me maybe half a dozen times, "Well, we need to speak to the arresting officer and figure out why he didn't do his job right," basically. But they didn't say that. They said, like, "We have to speak to the arresting officer and figure out why he made these decisions."
It doesn't matter that you're reporting a crime. The other case was dismissed. You have evidence right now. Make official.
Exactly right. But what they were more concerned about was protecting the
Yeah.
officer and the precinct from a lawsuit for the malicious arrest,
Yeah.
right? The unlawful arrest.
You're a
Than
lawyer.
they were about whether or not this guy got justice after being assaulted with a weapon in his home. This is a burglary and assault with a weapon. These are multiple felony charges.
Yeah, but this has been policing since forever. I think it's called like the thick blue line. It's on all those fucking flags and shit. They're a gang. They're just, that's just what it is.
But I remember
Police
the
safety,
sergeant
whatever the fuck
really
they call
wanted
it.
to agree with me. Everybody wants to agree.
Who
with me.
called the
They saw
cops? I
video.
guess. Did the aggressor call the cops?
He called the cops, the complainant. My client.
Yeah.
Or the defendant?
My client.
Wow.
And
That's crazy. Sometimes I always tell my clients that get caught in
Don't
a
call the
situation.
fucking police.
It's a race to the police. Whoever calls the police, whoever talks to the police. Sometimes it's whoever calls the police first, but then it becomes whoever talks to the police first, even if they both call, becomes the victim and the other guy's aggressor. And it's like they don't want to undo their work.
Sometimes I tell people, don't bring the state into your fucking life. Like,
Well,
why the fuck would you ever do that?
Like, people think that they're on their side, right?
Exactly.
Because
exactly.
not all cops are cut from the same cloth.
No.
Some of them really are on your side, right?
Yeah, but you're rolling that dice, and the vast majority aren't, because they're agents of a system that is there to, one, write tickets, and two, officiate arrests, and then assistant prosecution. That is their role in society. It isn't to take fucking cats out of trees and give fucking what are the fucking lollipops to fucking babies.
That's the fireman. By the way. Cats out of trees.
Whatever.
Right.
Whatever cops are supposed to do.
So lollipops are here.
Whatever cops do in fucking Westchester and Long Island.
We've gotten through all the. I'm like double checking. Everything else is either going to require the case to go to 30-30, or you're taking a plea. And if you're taking a plea, it's because it came before 30-30, right? 30-30 is speedy trial. So let's talk about the preference of pleas. And since we have a plea question, I think just lay down the foundation of plea bargaining and the type of pleas you can take, and then we can go to the question.
It really it's kind of like
Okay, I'll do it.
No, it really depends on the case. It depends on the person's record. It depends on a whole bunch of different factors. It less so depends on your relationship with the DA, because I find, you can develop that, like the personal interaction is less important. You can be
I think that's
friendly.
I think the exact opposite.
No, you can be nice and friendly with everybody. I recently had a DA in another county far away that I had no interactions with. I came into it asking for something incredibly reasonable on a case that I would have just smashed them on because there's like actual video evidence that shows their complaining witness to be a damned liar, and then there's a civil case going on which shows her to be a damned liar, and like it's just a bad case for them to try it, and we're asking for something reasonable, and like it just the first phone call interaction I had with her was just so aggressive. Now
On her part or your
on
part?
her, but I'm not aggressive with any DAs. I don't. That's not my approach.
Save it for the cops.
I'm not aggressive when I do. I like. So for me,
he's actually
my,
dead chill.
it's like I'm in costume like character mode when I'm a lawyer. And my personal feelings and emotions play no role in this. It's about my getting the best for my clients, right? And if I make it a personal thing, I'm not doing my job.
Yeah.
So like I have my own personal feelings, but I leave that shit at the door, and then I pick it up
Or
when I get home.
AWS couch.
Yeah, right. And no, I'm out of
This is therapy,
character.
friend.
This is me. This is me, real me. I'm not a character. So like I speak freely, right? But when I'm in fucking suit, I'm like, yes sir, officer. I'm all that bullshit. But so from the beginning, she's very aggressive. Now I know she was new because I looked her up before. She's only had like a couple years experience. So like there's this like everybody's out to get me type of a thing. But like I'm like, listen, I'm just asking questions. I'm not being accusatory. And once I like calmed it down, we had a great rapport. And after sharing the stuff that I had, I got the exact offer I want.
Yeah.
Right. And like, so what I'm saying is, it's like you kind of got to know the reasonable deviations, and you can get the reasonable deviations if you know the facts. It doesn't matter the relationship as long as you're not a fucking asshole. And you can
I don't think you need a relationship with the DA like established over time.
Right.
But I definitely think
honey versus vinegar.
Yeah.
100 all the time.
I think Eugene is right on this. And here's why. If you go as a defense attorney to a prosecutor and you want them to credit what you have to say, you have to have a reputation worthy of credibility, right? If you're somebody who's loathsome, who every single there was a legal aid attorney.
Don't be that person in life though.
Literally, there was this legal aid attorney who accused me of so much corruption and the only attorney in my entire career as a prosecutor who ever accused me of anything, and would get on the stand and like lose their mind about like stuff I had no control over. Like at the time we had a statute 50A. I couldn't hand over the information directly to her. I had to hand it over to the court for the camera inspection. Mm-hmm. I put the packet together. I bring it to the court. I asked them for the inspection, and every court appearance she would lose her mind, accusing me of corruption, even though I'm following the statute and giving it to the court. It was maddening, right? If that person called me and told me, oh, this person's innocent, I'd be like, I don't believe anything you have to say. You just say random stuff whenever you want to.
Yeah.
Now, don't get me wrong. I've never, ever hurt a defendant because of a lawyer. But, like, if the basis for what I need to do is your credibility and you're loathsome, it's not going to be helpful. And there are some attorneys out there who, like, they are terrible at negotiating because they've created a negative space for themselves. They're not going to get credit. If you need people to listen to you,
have a good reputation. Be a good person. Be personable.
It's a
be able to engage with people. And so there are lawyers that have that problem. There are defense attorneys, and from my observation, that have that problem because they're putting up an image. Whether it is that they don't really believe in the work, or they can't really identify with the client, and they're putting up an outward image because they feel there's a gap there, or whatever the fuck, or it is that they're just overly like angry. I don't really understand that because I'm very overly. This is personal work to me. And it angers me how absolutely deprived of humanity and just cruel and cold this fucking space is. Like the only multiple time.
I'm not sure.
Yeah, whatever. that I get upset is when my clients are treated with the lack of humanity and dignity that should be shown to every fucking person on the fucking planet, regardless of what they're charged with, because all of my clients are fucking innocent until proven guilty, right? And so yeah, being personable, being able to I had great relationships with almost all of the DAs in Manhattan that I constantly work with, because you're constantly with them. I never just heard or sacrificed.
They don't have to like you. You don't have to like each
Oh,
other.
but
It's about having respect and being credible.
100%, not being an asshole.
And
Which is like, why would you want to be that person in life anyway? And don't go around treating people like shit. Like, that sucks.
You're not an effective advocate if you are the enemy.
100%.
And I feel like we're like talking about the substance of it, but just for someone who like lived on a rock, like I guess explain plea bargaining like in the big scheme. And this is like basically how like 90. It's always like on television, like 97% of cases get resolved.
Look, the truth of the matter is, right? It's a negotiation, right? The prosecution has a case that's provable. By the way, that's important. Do they have a case? Do they have a crime that's provable? They might say we have rape 1 that's provable, and you go, no, you don't. You have rape 3 that's provable. But really, this is a forcible touching case, and we're asking you for a conditional plea. Here's the reasons why, right? Like that's a conversation that you're having, and if you're credible and you're explaining, and they respect your input, and you're not someone who says wild things for no reason, then you can have a real conversation as professionals. But like, it's the assessment you're making is, this is what they're accusing. This is the evidence. This is what my clients informed me. My client has corroborated these elements. I think we can work out a plea deal that will either keep this person from being a sex offender, giving them multiple years in prison time, getting them something that gets them programming, treatment, services. Right? You are giving up responsibility. Right? That's what the plea is. You're taking responsibility to some crime, and you are obtaining a lesser sentence, services, programming, something that will allow your client to come out the other end of this, hopefully in such a way that they have a real second chance, right?
Like you're typically pleading either to a lesser charge or a lesser sentence.
Yeah.
And if you're not, it becomes a question, then you might go to trial, right? Because
it's a simple calculus. If you go to a case and the prosecutor is only saying to you, I want this much prison time, and the minimum at trial is half that, then there's no conversation to have.
I mean, there are a lot of things that you're right. There are times when the DA is unreasonable and irrelevant, and you can just go straight to the judge. And that, I guess that
that's the other thing, right?
That's a whole separate topic, guys.
Well, I mean,
so
it's kind of
judges can give you a plea to the top charge,
they can.
But they also can't remove charges. So, for example, if you have an indictment that indicts a pattern of events, and there's different crimes on different dates, in different locations, and you have to plead to the whole indictment because the prosecution requires a plea to the whole indictment and not just the top charge, or you have multiple top charges on different dates. That could be a problem because that could trigger the statutory sentencing provisions that require consecutive time. So you have to be very careful, right? Like certain rules apply to make that go against you. So it's almost like by indicting cases in that way, they take away the judge's ability to give you a fair.
Yeah, because they can't, and there's some, and they can't, right. And so like another issue, so this happened a lot in Manhattan, where like I'd have a guy who would, who was charged with like a fucking not an indeterminate fucking low, non-violent felony, and the DA's office was asking for actual fucking prison time, and I'd have to just be like,
first arrest.
And it's like you're fucking insane. And then they would just remove themselves from the fucking conversation of what to do next, and I just go straight to the judge, and the judge would be more reasonable, and I get like fucking probation or time served,
A lot of judges
city bullet.
A lot of judges are reasonable because, like, again, I think that if you're the prosecutor or the judge, like some prosecutors care more about punishment, but I think the majority of prosecutors and the majority of judges care more about responsibility than anything else. I think, and that's true. That's true for the federal government, and it's true for the state government. Responsibility goes a long way. Taking responsibility, voluntary admitting fault, admitting that you've done something wrong, and doing it fast and efficiently. There is a calculus for that. Even in federal government, by taking responsibility, they give you 3 points off your offense level calculation.
They do like that responsibility bullshit. I think that's like a cover for, and this is just like cynical, and I'm kind of being an asshole, and I completely mean this too.
I completely mean this.
No, but I think it's actually like the whole like when I go to DA's office and like my whole DA is always in Manhattan because that's my most experience. And like I see like we serve the victims and stuff like that. And I'm like, oh, that's just to make you sleep at night for putting all these fucking black and brown people in prison for extended periods of time and stuff like that. It's like you don't care about the victims because sometimes I come with the victim asking you to do something for the person and you don't care about that. You get them to sign a document and then they're fucking irrelevant. It's just about your means to continue to fucking move the system ahead. But I think it's more about clearing the calendar. It's more about
for the judges for sure.
For the judges.
That's what I'm saying. Like, it's fucking with it.
The judge,
I gotta go to trial. Actually, just take a plea now. I'll give him probation if he takes it right now.
You know what I'm surprised by now? That I see this.
No disrespect.
A lot of the judges don't make offers anymore. Like you're in court, prosecutor and the defense can't come down. They're not making offers. I
still see that. I still see that.
I get invitations to request an offer all the time.
Yeah,
I get
for
that
example,
too.
like I had a case where
where
I needed an offer, and I went to the prosecution. They were on board, but they couldn't go down level, right? Like they couldn't go down level, but they were willing to allow a plea to specific charge without the consecutive sentencing that would happen if there were other charges. So then I had to get the prosecution to agree, but then I had to convince the judge to give me the additional year off. So it was like I got the sentence from the judge, but I got the plea charge from the prosecution by their admission.
You had the plea charge from the DA, but the sentencing you had to convince the judge.
I had to convince the judge. So basically the prosecution.
Oh, okay, I see what you're saying.
So the prosecution was like, I'll give you a plea to 8,
but I'm not gonna have a recommendation.
But I needed 7, right? So I said, look, can you confirm that you won't object if the judge is 7?
I've done that before too.
Okay. And so that was key.
Before we make it more complicated, questions. Yo?
I have a rule, and I tell my clients before they hire me that if they come in and they tell me I'm innocent, and that's 100%, like that's what they're telling me, I didn't do this, I wasn't there, then they have to know that they can't hire me unless they understand that I will not go to the prosecution and ask for a plea when you're telling me you're innocent. I just can't do it. Like I find that unethical. I find it wrong. So I won't take the case. I'll tell them, look, you'll have to find a different attorney who feels comfortable allowing an innocent person to take a plea.
Yeah. I tell my clients, I don't care if you're innocent or guilty. I just want to get you the least amount of everything. I want to get you out. Yeah. In fact, it's more prideful for me if you're guilty.
I can't make an application in the court saying that I have basis to believe this person committed this crime. If the person's telling me they never did it, like that feels unethical.
I agree, but I think
there's even case law that you can't maintain innocence and
given the agency for our clients is, I think.
But even if like it's a significant ride, right? Because
the
criminal justice system is a ride.
Right? How can I let my client go under oath and take a plea and say I did this? If they're telling me
it's their life.
It's his life to do that.
Well, we're being sexist right now. It's their life.
But remember,
we have female clients.
But remember, I have to, as the attorney, make an application, and if an ethical judge is going to ask me the question, do I have any reason to believe that this person should take a plea? The reason is going to be they're perjuring themselves because they're telling me they're innocent.
Everybody perjures themselves in that. Nobody gets prosecuted.
I mean, I don't know. I hear what you're saying. I think that's a separate episode.
I agree with you.
By the way, take note. Ex-prosecutor, defense attorney, private only, former institutional defenders. This is a difference in training.
I do believe
this is a drastic difference in training.
I do believe in clients' right to dictate their own path in this.
Oh, and they do. They just don't have the right to have me as the attorney for them.
Yeah. I'm not anybody's daddy. I'm just
and
what are the risks of accepting a plea deal, especially for someone who is innocent or overcharged?
Oh wow, that's
what are the risks? I mean,
what are the risks? I mean, I think fundamentally
getting a criminal record. It's a bit. I mean, getting with the criminal record comes certain not only actual punishments that can be attached to that, like jail time or prison time or probation or community service or lesser degrees, but it also comes with collateral consequences of having a criminal record.
Well, I mean, so what are the risks of taking a plea deal if you're innocent, right? Like, I'm hearing that question kind of more because look, fundamentally, if you take a plea, it's not a risk, right? There's a guaranteed consequence of your plea, right? So it's not a risk. It's very laid out what you did or did not do. You are giving up certain things, right? Like if you are innocent and you take a plea, you're giving up your right to sue under many cases. You're giving up certain things, and that's another consequence. Mm-hmm. Now, the darker, like if you're asking me risk, right? The darker aspect of the criminal justice system of being innocent but not taking a plea is being convicted of more than what that plea was worth, even though you're innocent. And that's like the real risk. Like unfortunately, like that, like going to like what we kind of were talking about, which is this idea of like, would you allow your client if they tell you they're innocent? One, I think fundamentally you don't know if your client's really innocent. Yeah, right? You don't know. You just don't know.
But like
so
again,
you can't really say they're perjuring yourself because you personally were not there, so you don't know what they.
But that's the problem. Your client has trust with you, they privilege with you, they have privity with you, right? They're telling you, I was not there, or I did not do this, or it was somebody else. Those are all defenses, right? And if you're asked by a judge as an officer of the court, do you have any reason why this person should not take a plea? Those are all reasons as far as I'm concerned.
Yeah, so like let's try to like let's put this into like real world like examples. Like a real world example would be a case where a client has a really extensive record. He gets into a fight. There's serious injuries, and he's charged with assault 2, which is a D felony. He's a persistent. That's like he's a mandatory persistent. It's a violent felony. So like that means if convicted,
he's facing life.
Or if convicted, or even if he pleads to the felony, he's facing like life or serious jail time,
prison time.
They offer him a misdemeanor, right? They offer him a misdemeanor in that situation, and the innocent part is he has a definitive self-defense,
a real justified, justified.
Definitively, he didn't start the fight. Definitively, he was defending himself. Yeah. It becomes a situation where the reality is, this is a he said, she said situation. The reality is, unfortunately, on paper, right? Like let's make this as exaggerated as possible. It's a 6-year-old grandpa-looking motherfucker, and you're a 25-year-old young-looking strapping guy. And this guy comes at you insane, he's hitting you with a stick, and you're defending himself, and in the process you push him, he falls, right? Yeah. You're defending, you were legitimately defending yourself, but unfortunately there's no empirical evidence, it's just your word versus his word. And what you can do is go to trial and allow this prosecutor who believes the victim to present this case to the full extent of the law and potentially be convicted, or you can take a misdemeanor even though you have a valid self-defense and avoid all that real risk.
What if you're in jail?
I feel like those are the real conversations that we have with our clients.
I love that example because my immediate reaction to that is you have a duty to retreat in New York State, so you have to run.
So what if there is no retreat, right? What if they're in their home? What if we're in a situation where your client has been incarcerated for X amount of time and they're offering an immediate out, right? With a limited amount of things.
Yeah, but again, he did it, right? He pushed the guy, right? The question is, does he think that the self-defense is going to be something can disprove beyond reasonable doubt? And that's the real question. You have to make that's a strategic decision.
They always do it, right? That's the whole thing about justification.
But that's the thing. What I'm saying, that's not an innocence defense. That's a question of whether or not the defense you have is strong enough to overcome.
I mean, but every defense, every trial is a roll of the dice. Right?
Yeah, but again, I'm telling you about a guy who says, "I wasn't there. I was at."
I mean, I think that guy is like, if we're gonna bring it to the real world, that guy is still Kevin, right? And he's innocent. He's innocent. Just saying, he's innocent, Kevin? Right? Like just in the
you're right. It is Kevin.
And if he was offered a violation or a misdemeanor, and he said, "I want to take it. I want to be free." Fuck, man. Like that's
look. If you're in a situation where you have somebody who is defending themselves, it's clear as day, right? and they're offered a violation as opposed to having to go to trial on homicide, well, buddy, that's a win.
Yeah. What about
That's
a
no criminal record.
What
I
about
thought we were talking about perjury.
Well,
That's
what about-
fine.
Because again, you're missing the point. Self-defense means I did it, but it's justified.
But isn't that just as innocent as like
No,
I
no.
wasn't there?
I'm talking about a guy who's like, I wasn't there. It's impossible for me to say
I don't
did
see the
this.
I don't see the ethical difference.
You don't see the ethical difference.
No, because I still have to prove
It
to a
wasn't
jury.
me. I wasn't
I
there. It
still
was
have to-
somebody else.
I still have to prove
and
to
it
a
was
jury.
me.
I
But
still
I was
have to,
defending
I
myself.
still have to prove to a jury that. And I
let's-
still have to
let's-
prove to a jury that.
I
Right?
feel like,
So,
I feel like
to me-
unfortunately we're talking too much
And we're not
like
answering-
shop.
Yeah.
No, like let's put it more something that the audience can understand. Because look, we're having a very like this is like real conversation that really happens every day when we're discussing with our clients how we are actually going to resolve their case.
Yeah.
This is like the real meat and potatoes of that conversation. But I think we have to put it in more like concrete terms. For example, someone's accused of robbing someone, right? They're accused of robbing someone. They get found on the block. At the end of the day, the person identifies them. Maybe they're wearing something different. Maybe they don't actually have the physical property. And what they're saying is, look, I didn't rob this person. Like I didn't rob this person. They didn't find the thing on me. But unfortunately, they're incarcerated. Unfortunately, they have a rap sheet down the fucking wazoo that says they rob people, right? And even though that's not going to necessarily all come in. And the real important thing that is because this person's saying you robbed them. So you can tell me you didn't rob them, but this person's saying you robbed me. So it's just a risk-reward analysis of going to trial with what's in front of us, right?
Now, I'm never going to push that client, especially if they're innocent, to take a plea. But it's if they like, I can't make.
Yeah. I think the worst thing of any defense attorney,
You know what?
all
I
public defenders could do is this is what you got to do.
Yeah.
Like this is what I'm telling you.
The decision to make a plea is the client's.
100%.
Of course.
The decision to testify is the client's.
100%.
Decision to go to trial with a bench or a jury is the client's.
Yeah.
You have no control
God,
over
that
those
one's
things.
scary.
That is 100% the client's decision.
Yeah.
The question isn't whether or not the client is allowed to take the plea and take responsibility and say, I did this. The question is, right, what are the risks to doing so?
Right.
And the risks are you waive all your defenses.
Mm-hmm.
So, for example, self-defense is something you have to show clear and convincing evidence of. And you have to meet the standard. You have to get a judge to instruct. There's no guarantee you'll get that at the end of the trial. So it's not as solid. But and another thing, misidentification, right? That's a defense. It's a big defense, right? But people get misidentified all the time and convicted.
Yeah.
So you have to explain that to clients. You have to make sure they understand. But there is a difference between misidentification and person's in custody because they can't make their bail and they're saying they have an alibi and that they didn't do it. Like, and you simply got, by a stroke of bad luck, it's been 3 years since this happened, so you can't get video, you can't get witnesses, you can't, and all of the evidence you need is not available, which, this case, I've seen this case, right? What is the situation, right? That client, most of those clients, honestly, when those clients come to me, they want to go to trial. When you're an institutional defender and you're in the system, you're in the meat grinder.
Yeah, you have different set of
You have a different set of expectations. Yeah. But my point is, I tell clients, if you want someone to fight for you, that's what I do. If you want somebody to represent you, you can just get somebody for that. You don't need someone special for that, right? Like, come to me when you actually want someone on your side, right? And that's really my mentality, right? They have to help everybody, no matter what, when they're institutional defenders. I know I'm pointing at Dave, but he's not institutional.
It's okay. You're pointing at me for the guy who killed somebody earlier. So I'm just that guy.
No. But what I mean is these two gentlemen in front of you, their mentality is everybody needs the best options, right? But that's not what I do, right? Like, people come to me because they want the best possible future. They want hope. I'm willing to fight for hope, right? That's what I do. That's what I choose to do. That's how I do this, right? And if you're telling me you're innocent and you're unwilling to admit to me you've ever done anything wrong that would possibly make you connected to a crime, then you really shouldn't hire me. You should hire somebody else if you want to take a plea. You want to hire me, you're hiring me for a fight, right? Like that's what we're doing. And that's the other thing. I feel bad taking money from somebody who doesn't want to fight. Like, why would I do that? That's not ethical to me either.
Yeah. I mean, I think it's like it's a really fine line to walk, right? Because I consider myself a very hard line fighter for my clients as well. But the way I look at that is I want to fight to get the best outcomes for them, and that could mean a lot of different things for a lot of different people. And when at my time in legal aid, I did more trials than most of my colleagues that I started with, and I did that without what I thought was losing my I realized very early that I had a lot of influence over my clients. I could influence whether, and this is the reason why I think there are people that can go a long time without doing a trial as a public defender. And Manhattan is harder to do that because it's a more aggressive borough, but like we have a lot of control over our clients, and I could convince a lot of my clients to do something for myself because I enjoy doing trials. But like that's not always the best thing for somebody. Now, my clients as a public defender were the majority of them were homeless or severely mentally ill or had severe drug addictions, or majority had a combination of two or all three of those.
I mean, look, I totally get what you're saying, but my point is the risks you're taking, right? When you walk in front of a judge and you say, and your lawyer says, I am making an application for this client to plead guilty to this charge, knowing that they're going to face probation, sex offender registration, programming, that if they screw it up, they're going to go to prison, right? Like when you're having that conversation in front of a judge in the court record, with the transcript being written down and everybody listening, you're making the decision to tell the court, I am willing to give this person up to you. And then when you do that, your client then gets asked a lot of questions. He gets asked about, you understand you're waiving your right to a jury. You understand you're waiving your right to challenge the evidence. You understand you're waiving your right to raise your defenses. That's the big one. Waiving the right to these defenses. You are voluntarily. Do you know why they ask that question? Because the system allows you to plead guilty even when you're innocent. Because you're waiving your defense. Self-defense is a defense you have to establish, and then the prosecution has to disprove it. For example, intoxication is not an absolute defense. It doesn't completely justify your behavior, but it can lower the level of culpability and give you a better charge. You're waiving that. You're saying, you know what? I'm taking this because I really don't think I can do that.
Yeah, I think the question isn't the willingness or the fight. The question is the control of the decision of the client. You said that if my client tells me they're innocent, then I will tell them I will never have a plea because of the whatever perjury or ethical responsibility. And that I think is something different. For me, it's like whether you're innocent, guilty, whatever, I'm going to fight and leave nothing there. But like the decision is solely within the client, and that doesn't mean I obfuscate my responsibility of explaining everything.
I think what it is that fundamentally he started off as a prosecutor, so he started his career with only defensively representing people that pay him, right? So this is a conversation that you're having with someone who's about to give you cash money,
and
right?
They're not stuck, right?
They're not stuck,
right? That's it's
they're
a
not
different.
stuck.
It's a
They're
different
not like they have options,
I'm
right? And
not,
he's saying,
I'm not
don't
saying what you're
pick
doing
me.
is wrong. I'm saying for me as the attorney who's being hired, who they're coming to, I only want to do it if I'm doing it for hope.
Yeah, that makes sense.
But that's how I choose.
But before we
100%.
keep going, any more questions?
Wait, can we finish the answer about risks? Because we didn't finish the answer.
Risk?
We were talking about risks of pleading guilty.
Yes. Okay. Go.
Right. So you waive your defenses, but the biggest one, the one that I think people don't understand or appreciate the value of, is a lot of these pleas involve a waiver of your right to appeal.
Yes.
And that's a big one, because sometimes people think
It's limited.
that the jury is not going to listen. Is not going to believe you. they're not going to consider the evidence. This jurisdiction is not fair, whatever. They take the plea, then there's a requirement of a waiver. So the sentence, the plea to the charge, all of that can't be disputed. So then, the judge asks you on the record, is anybody forcing you to do this? So you can't say it's coercive. They ask you on the record, are you happy with the representation of your attorney? So you can't say your attorney's ineffective. You can try, but it's going to be harder, right? They're going to ask you if you've been advised of immigration consequences. And if you've been advised, right? Now, some immigration attorneys will tell you that you have a duty to mitigate immigration consequences. But the truth of the matter is, I just don't agree, and that's not what Padilla says. I'm sorry.
I agree.
Okay? Like, say it as much as you want, it's not true.
You have a duty
To mitigate immigration consequences.
Which means like
You have a duty to advise.
Well, you have a duty to
You have a duty to
advise.
understand them.
yeah.
How would you? How
It means like tell you wouldn't take like if your client has his only option is to take a plea that could be a CMT.
Like
or
if you're
something
pleading
like that.
possession of a controlled
Yeah,
substance.
but I mean, if that's your
Only
only option,
option,
how are you
yeah.
gonna mitigate
Exactly,
something
they
that
can't-
you
they're-
can't?
they're fucking immigration
I
attorneys,
mean, I
they
take
can't
them
tell
to
us.
trial and watch you get convicted on the felony.
Exactly,
possession.
they're not. They're
That
not.
makes no sense.
This isn't their area of practice. They can't butt their nose in and say how to do our
Well,
job.
these same attorneys work with the public defenders who are trained to think that, and it's not right.
No,
They're
we
doing
were.
that's a
we
disservice
were,
to their
we
client.
were
No,
not
that
trained.
doesn't make
We were.
sense.
We
You
went
tried-
to.
I just did a training
your
on this.
your
You
representation.
try your best.
Yeah, your
you try your
representation
best
is
to protect them,
Yeah.
but that you're not trained to.
And
not
I'm
take
telling you,
it.
I just did a training with the institutional defenders run by legal aid and the other divisions. It was all 5 boroughs, and the training resource, which was specific for institutional defenders, was telling them they're responsible for mitigating immigration.
No.
So-
I think you're hearing it wrong.
Oh
They're
no,
responsible-
it was written. I'll show you.
No,
I'll
no,
show
no,
you
no,
the
no.
spreadsheet.
What I'm trying to say is that they're responsible for making their best
efforts
to mitigate.
100%.
But you cannot.
Even that's
Yeah.
not true. Padilla requires you to know and advise.
Okay, so what I'm trying to say is it makes sense that the legal aid or any organization is saying
You should.
we are going to go above and beyond.
100%. 100%.
What's the case called?
Padilla.
Padilla.
Yeah.
We're going to go above and beyond
Yeah.
Padilla, and we are going to make sure to do our best to mitigate, such as asking DAs for immigration-friendly pleas. You need to go above and beyond, and that makes
That's
sense.
good,
It
that's
comes
good
from
training.
the
I
organization
agree.
itself. Yeah, that makes sense.
That's good training.
Now, can
That's good
you
training.
mitigate things outside of your control? No, you can try.
100%.
You can't force them to be
And
mitigated.
the criminal,
if
the
your
criminal
client
liability
has
will
that,
first,
like
period.
this is an example for example, if your client is arrested, he's got a drug problem, he's caught dead to rights on cases, and you're offering them programming, and they're telling you can't take that plea because the program, there's too much risk that if they don't complete the program they're going to get deported. Well, I think you're missing the point, because you want your client to succeed, you want to advise them, you want them to have treatment. You don't want to leave them in jail
I agree.
pending
Agree.
when they could be in a program and
Agree.
getting services.
Agree.
Right?
Agree. I tell my clients you need, regardless of what happens, you need to talk to and hire a fucking immigration attorney. Because like you're right, my responsibility, my role, and my advice is always prioritized through the criminal.
And then that's
criminal
the other
way.
thing. Private attorneys don't, we don't usually build into our retainer that we're going to hire you an immigration attorney
No.
unless it's discussed. But I will require you before I take a plea to go and speak to an immigration attorney, and I'll even refer you to a few of them, and they will do an opinion letter for you for a reasonable fee. But like,
Requires
at a
too strong a
certain
word for me. I'll advise you. You should probably.
no, you can't take the plea if they haven't been advised. Unless you know the advice. How would you take the plea?
Wait. Take. What do you mean?
Someone is not a citizen. They're offered a plea. You don't know the immigration consequences because you're not an expert in immigration.
No, but you
They've
know,
gotta go get advice.
you know a baseline enough as a criminal defense attorney.
but you don't know
how to
everything.
advise them, and you can advise them. If your part of your advice to them is to also seek to give them that baseline and to seek
See, that's a violation of Padilla, because you have to actually advise them. Which means if you don't know the answer or you're not qualified to it, you have to get the answer. So that's why I tell the clients, like, you have to go do this, otherwise we can't take the plea. And here's why. Federally, for example,
Is that how
if
you
you get
look,
a plea
the
to a
way
certain-
we have
Yeah, but your immigration specialist never speaks to your client before they take a plea.
No.
You go to them and you ask them questions. Is this a plea that's safe?
No,
And then they say yes, and then you say this is good. This isn't going to give
I
you
think we're
any
talking
issues.
very like
we're talking about more complicated things. I'm talking about you got a permanent resident. permanent resident needs to take a plea to a charge, and there's a fine consequence. You have to know that if they get more than $10,000 on a fine, that is going to be an aggravated felony in immigration land. And if you don't know that, and I didn't know that until I got an opinion letter from an immigration attorney who handles these cases and was able to. And by the way, they didn't know off the top of their head either. They had to do research to figure it out. Yeah. Right? There's certain things like, for example, we know that a discount and time served generally going to be great.
I think what he's saying is that depending on exactly what the situation is, you might need more than what your general knowledge can provide you.
Yeah, I mean, like, we know that.
And if the situation calls for more and you don't get more, you're violating.
Yeah, which situation I could but in I guess what are those situations? Because we know the felonies you're fucked. I mean, right? So it's like that advice is easy.
Immigration is
most misdemeanors, you're fucked. I mean, that advice is easy.
But sometimes, for example, like I said, the example I gave is a good example because it's a permanent resident.
Mm-hmm.
Their concerns were naturalization or not being allowed to renew their residency card. There's circumstances in which you can't renew, or you will be denied, right? And you'll become undocumented. So you have to know what those are. That becomes more complicated. It's obvious for somebody who's undocumented, right? And it's obvious if it's drugs, if it's domestic violence, if it's
right. Know the crime of moral turpitude, and then
but we're talking about the more complicated.
No. They need to speak to an immigration attorney because you can't expect defense attorneys to be immigration attorneys
unless they're both.
We're talking about
and
something called crimmigration, which is its own episode. Are there immigration?
That's the thing.
No.
That's what I'm saying.
The consequences of criminal law on immigration is called crimmigration. That's how significant it is. But all right, look.
Were there two questions?
Huh?
I thought there were three questions.
No more questions, right? No more questions. But look, we definitely can't fit this into one No Rules episode. But what I do feel like is the only thing we left on the table is going over all the different pleas, which I think we could do on a separate episode. And what's on the other side of the episode, what's on part 2 of this episode would be things that happen when you don't take a plea, right? Such as things that can happen at a hearing, all the things that could resolve your case, such as evidence suppression, acquittals,
trial omissions,
trial order dismissal. Yeah, there's a bunch of things that can happen once you agree we're going to war. And we can discuss those.
By the way,
which is the best part of
when we're talking, because we're just talking about pleas, it's important to know something. While we're keeping while your lawyer is trying to keep an avenue open for a plea for you, they're playing very nice. But once we've stopped doing that,
no more niceness.
Nice goes out the window.
Yeah.
Once you know there's no reasonable option for a plea,
no.
Your lawyer is
we're creating voodoo dolls and we're taking hair from the fucking DA. And
trust me, the animosity is there. Okay, there's no punches pulled in that.
No.
And that's kind of where speedy trial comes more into play, which is why it's going to be on the second half. Of that.
Just a side note: if you are facing a criminal case, don't just trust your lawyer. Pay attention in court.
Ask questions.
Understanding.
Ask questions.
Take notes.
Yeah.
Take notes, because if you ever decide I don't want that lawyer, you want to know what date your case was.
Yeah.
What happened? Every day your case was and what happened.
There are a lot of lawyers that will take your money and give you less than adequate service because they don't care about what happens to you, and they know that the vast majority of people that they come across don't know what's going on, don't have connections to other lawyers, don't know when somebody is screwing you over. A lot of cases that we come across that we pick up from other people are messes because
disasters.
Because people suck.
These two are not like that. So before we get out of here, please give them your information so they can find you in the interwebs.
I was gonna be like this, but this is a live.
This is a live episode.
So just hit me up on my phone line, the website, and everything's gonna be up. 907-572-8599. You can call me anytime.
My website is esmidilaw.com, ESSMIDI law.com, and my office line is 917-905-2527. And you can find me on their pages for all my social media.
Yes, and like you guys know, catch me if you can. This is Attorney Swag.
Don't catch him. Why you setting people up for that?
I love it.
Catch me in a payment.
Catch me if you can.
If you can. I'm not saying you want to catch me. I'm saying if you get charged with a crime,
if you get caught, Catch me if you can.
By the way, that's the next T-shirt. That is catch me if you can. It's just Eugene, like, you know,
a get out of jail free card on the T-shirt.
Yeah. And like, comment, subscribe. If we didn't catch anything, we definitely will be doing a part 2. Thank you guys for being here. We're out of here.
Attorneys as well. Show you a couple of wives. Watch attorneys talk about the law.
Yo, this song's in the key of life. We reppin' the people's rights. No matter how dark it gets, the beast will come out at night. So call me a trick-or-treater, always a calm demeanor. Whether you looking at life or just a misdemeanor. Whether you're smoking weed, whether you getting green, whether you caught up in some shit that you didn't mean. Just believe us, we trying to teach you the rights to read you. It's just procedure, baby.
Trials, instruction, procedure. AWS gon' teach ya. Trials, instruction, procedure. AWS gon' teach ya. Yo, here's a tip. Don't get it twisted. Stay focused on the message or you gon' miss it. When your case go to trial, it should be hitting different. The jury of your peers, do you really wanna risk it? Just because you're innocent don't mean you in the clear. When you try to tell your story, no one cares if you're sincere. The trial carries on and you try to prove your worth.